All rise. Oh yay, oh yay, oh yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to the February 2022 Tennessee Supreme Court docket in Nashville. We are extremely happy to be here in person. We appreciate all of you persevering with us through the 2 years of Zoom court, but we're happy to be back. I want to welcome those who are also going to be watching argument on our YouTube channel and live stream this morning. I want to remind you all that, of course, it's usually 30 minutes a side. We're going to have 31 per side this morning because the interveners made a motion to split their 15 minutes into 7.5-minute increments, and which was granted. Unbeknownst to me, our timer can't do seconds, so you'll get 8 minutes split, and of course the appellees, the state will still have 15, but the appellees will have 31. I want to welcome this morning Judge Frierson from the Court of Appeals. He has spent a lot of time getting ready for this case and acting as our special justice, and we appreciate his being here this morning. When you come to the podium, I guess this will only apply to the state because the interveners have told me they're going to do 7 minutes and then 1 minute in rebuttal. So if the state will tell us how much rebuttal time you're reserving, as I said, it'll be 31 minutes per side. Mr. Hivner, you may call the first case. We'll have 2 cases this morning on the docket.
Metropolitan Government of Nashville and Davidson County et al. Versus Tennessee Department of Education et al.
Good morning. May it please the court. I'm Andre Blumstein, here this morning on behalf of the state, and if I may, I'd like to reserve 2 minutes for rebuttal. The ESA pilot program is part of the general law that governs LEAs in how they provide primary and secondary education in the state. And the pilot program is intended as a first step in giving low-income children in Tennessee's lowest performing schools the same opportunity that more affluent, more privileged children have to get an education that is best suited to their particular needs. The plaintiffs are challenging the pilot program in this phase of the case as a violation of the Home Rule Amendment. And with the court's permission, I would like to focus on 3 issues or 3 reasons why that challenge should be rejected. 2 of them are threshold issues: first, standing, and second, ripeness, and third, the fact that the challenge statute is applicable to the LEAs and not to the counties. So even though this is a declaratory judgment action, the plaintiffs still are required to establish standing, which means that they've got to show more than just a speculative harm. If the controversy depends on future or contingent events or involves a theoretical or hypothetical set of facts, it's not justiciable even under the Declaratory Judgment Act. That act, and I'm now quoting from West versus Schofield, does not give the court jurisdiction to allay a party's fears as to what may occur in the future. The plaintiffs can't.
But under this issue, we know that as currently enacted, the school voucher statute, the grant program ends after 3 years. That's not hypothetical. It will only be extended if there's further legislative action. So as enacted, this grant program ends, and there will be a very direct financial harm. Will there not be?
Well, there is nothing in the record that supports a real financial harm. The plaintiffs did not, this case is here on a motion for summary judgment. And I think it's important to recognize that the plaintiffs did not consider financial harm to be material to their home rule amendment challenge when they moved for summary judgment. And we know that because in their Rule 56.03 statement, there is absolutely nothing about financial harm, nothing about financial impact. They didn't mention any of the facts, the numbers on which they now rely, nor did they present any of their calculations that are based on those numbers. So they're not even, those underlying numbers are not in the record.
Well, how are we considering those numbers then? I guess you say
Well,
we
what
should
I'm
not,
saying
but
is
how are they before us?
They're not before you.
Okay.
And therefore, what the plaintiffs have to say about the harm that they might incur is speculative, hypothetical, not based on anything that is in the record. And they do point, if I'm remembering correctly, they point to the corrected fiscal memorandum that is in the record. But if you look carefully at that fiscal memorandum, or even not carefully, if you just glance at it, it is clear that the numbers in that fiscal memorandum are based on assumptions, ifs, guesses that are being made. And
Counsel, I don't understand your argument in the context of a declaratory judgment action. I need you to address that, because what they've done is calculate the dollar amount that the counties will have to come up with under the ESA. And we have amicus saying, we have students ready to sign up for it. I'm not understanding how that is not demonstrating the injury they will incur under the ESA.
Well, the calculations are based on hypotheticals.
They're based on formulas, the BEP formula, and the county's statutory obligation to conform with the counting requirement.
They're based on numbers that are hypotheticals, guesses, estimates as to what will occur in the future. And let me remind the court, too, that the plaintiffs have said repeatedly that their appropriations are not going to change. Their appropriations are going to remain substantially the same, whether the ESA program is implemented or not.
But that begs the question, because what the ESA does is require the counties to continue to count students who are phantom students, who have left the public school system and gone to private schools. The injury is derived from the fact that other counties don't do this. So the fact that they have an exception, there's an exception specifically for these two counties that requires them to continue counting students who are no longer, who have gone to private schools. So that seems to me the converse of not recognizing how the ESA works.
Well, again, all I can say is that they have said repeatedly that their appropriations are not going to change. So that says to me that there is not an adverse fiscal impact. And let me also quote from the Chancellor's memorandum opinion here, where she says the amount of associated BEP funds, this is in part of her findings of fact, The amount of associated BEP funds that will be involved is unknown until the program is implemented. And then she also explicitly declined to make findings of fact about how the math will work. That's also a quote from the opinion. So there's nothing in the record to show that there is an actual fiscal harm.
Counsel,
Certainly not to the extent that the plaintiffs are claiming.
If there was no financial harm, then why would the legislature adopt a 3-year grant program to offset the loss in revenue?
Well, that might be one of the reasons why they say that their appropriations will remain the same. I'm sure that's one of the reasons, because if there is an offset, then there is no fiscal harm.
But that offset ends after 3 years.
Well, and there are other payments that will be made at the end of 3 years. And in addition,
what other
the
payments
program
will be
may be
made?
discontinued. I'm sorry.
What other payments will be made after
There's
the
a
3-year
grant
grants are in?
that will go to all priority schools, including the plaintiffs, for example.
Counsel, let me turn your attention just a moment to the merits. I think we all agree with what the Court of Appeals said about the 3 requirements of the Home Rule Amendment here to apply. 1 is the statute in question must be local in form or effect. 2 must be applicable to a particular county or municipality. And 3 must be applicable in either its governmental or proprietary capacity. Is your best argument on the merits here that this the ESA applies to LEAs and not to the counties?
Yes, it is, Your Honor.
Can you expand on that?
Yes. The Home Rule Amendment says that it applies, the language of the Home Rule Amendment is that it comes into play when it is applicable to a particular county. It doesn't say to LEAs in a particular county or to some other governmental entity. It's to a particular county or municipality, of course. And the Court of Appeals actually got this distinction, and it said that the ESA pilot program applies to the LEAs, albeit in these 2 plaintiff counties. When we talk about something being applicable to as lawyers and as courts, I think that the common understanding is that a law applies if it governs or if it regulates the entity. And here, this law regulates only LEAs. It does not regulate counties. And so read in context, and the context is important, that's why we say that the Home Rule Amendment does not come into play, because it does not apply to counties. It applies to LEAs. And we then have some precedent from this court from the 1950s, the Parrott case and the Fountain City case, that both talk about about the difference between counties and their school systems. In the Parrott case, it was a special school system, special school district, and this court held that the county and the special school district are totally separate. And so the Court of Appeals fiscal, and the only reason actually that we're talking about, or not the only reason, but one reason we're talking so much about the fiscal effects is because the Court of Appeals, after it found that the county and its school districts were separate entities, nevertheless brought the LEAs back in by saying, oh, there's a possibility that the counties could feel some fiscal effects if the LEAs did not have these students still enrolled in those
Counsel,
schools.
I'd like you to address that in the context of the counting requirement, which applies directly to the funding entity, which by statute is the county. I'd like you to address that argument in that context of the counting requirement.
The counting the student requirement?
Yes.
Yes.
I can give you the statute number, but you know what I'm talking
yes.
about.
Well, I think that the best way to look at that is to recognize that the students who get ESAs and use them to go to other schools are not leaving the public school system. And the county has an obligation to...
Respectfully, they are. I mean, we have to be real. So how does the counting requirement mandates that the counties continue counting students who have gone to private schools? Tell me how that is not applicable to the counties. But Mr. Chief Justice, if would indulge
Sure,
my
yes.
question
You
ran
may
over on her
finish.
time.
It is something that the counties have to do anyway. They have to count the students who are in their counties.
Have gone to private schools?
The students who voluntarily decide to go to private schools, the ones who can afford to do that, who are not trapped in low-performing schools, remove themselves from the public school system. These students are still in the public school system, and the counties still have an obligation to provide education for those students in the public school system.
So your answer is for us to imagine that the students who have gone to private schools are still in the public schools, and so that's why the counting requirement is not applicable to the counties?
They're still in the public school system through the ESA program. The ESA program is part of the public school system.
Okay. Thank you, General. Greater praise is next, Mr. Sawyer.
Good morning, Your Honors. Daniel Surf for the Greater Praise Interveners, and I'll ask for a minute as we noted. Let me pick up where we left off. I know there's a number of arguments in this case, but I want to focus on our second one, which is this question of the applicability to counties and cities. I think if you read the text, it becomes clear for three reasons that this law is not applicable to counties or municipalities. The first is the plain text itself of the Constitution. The second is the history, the Convention Journal, and the third is the precedent. So let me take each of those in turn. The first, I think, is just reading the constitutional text. It says applicable to a county or municipality. It does not say school districts. They could have said school districts in 1953 when they wrote the Home Rule Amendment. School districts existed at 1953 in the same form we know them today. They could have also chosen a broader term like political subdivisions of the state or local units of government, which might have included other types of entity. But they chose specifically counties and municipalities. You go into the Convention Journal, you ask, why did they make that choice? Chairman Pope is the person who wrote the final version of what became the Home Rule Amendment. And he says in the Convention Journal, I'd point you specifically to page 1121, that they made a choice to limit it to counties and municipalities in response to what they believed was the problem, which was the legislature reaching in and setting individual rules for individual counties and municipalities. You look too to the Convention Journal, you find an interesting change as the bill is moving through the process, that originally the title of the bill was Home Rule for Local Legislation, and they changed it to Home Rule for Cities and Counties, again suggesting this very specific focus on home rule for cities and counties. And we see that work out in the statutes, actually, that obviously cities and counties are the entities that exercise home rule. They have home rule charters. One doesn't find a school district with a home rule charter.
Well, but if a statute is shown to have a substantial effect on a county or a municipality, do you think the Home Rule Amendment would apply there when it is directed? Clearly here it's directed at the LEAs, but assuming for a moment that it also affects the county and a city substantially, would that not come within the Home Rule Amendment?
I don't believe it does, Your Honor, and I think the answer is to look at Parrott. So if you read the Parrott case, it's a very formalist and structural analysis that this court undertakes. It looks at the type of entity. And in particular, as you reach the end of the Parrott opinion, it's a short opinion, but as you reach the end, there's a paragraph where the court talks about Key, which is a previous case from 1926. And in Key, this court was dealing with the question, how do you look at a public school corporation versus a municipal corporation? And it distinguishes between the two. So the way the court is looking at it is in a formalist sense, what is the legal entity that this is being regulated, which I think, to pick up on General Blumstein, she's quite correct that the question is, how is a entity regulated formally by the statute? And here it doesn't formally regulate school counties or municipalities.
I'd like you to, I'm sorry, go ahead.
How do you reconcile that decision, though, with the Chattanooga Hospital Authority case, which found that Hamilton County was substantially affected, therefore had the right for local approval, yet the city of Chattanooga was not substantially affected and had no right for approval? And that private act was directed at the hospital authority, a separate entity.
It was directed at the separate entity. Again, I think you go back to Parrott and you look at the substantial effects test that the county is proposing here. Right. One of the things that the counties acknowledge in their brief is that the counties, it's in footnote 33, the counties were actually funding the school district in Parrott. It was a special school district. Obviously here we're funding general school districts, but they were funding it. And so the court in Parrott obviously wasn't bothered by that fact, right? So I don't think the substantial effects test works because in that case, presumably the county would have been impacted. The county did have this funding relationship, and yet the court still ruled that it was not covered by the Home Rule Amendment.
How does your argument work in the context of the counting requirement, which operates directly on the counties? Tell me a definition of applicable where it does not include a statutory provision that operates directly on the entity's obligation as to funding.
Yeah, so here the county receives a count from the LEA, right? So the LEA is the entity responsible under the statute for providing a count. That count is provided to the county. The county then has a responsibility under the BEP to issue a certain amount of dollars back to the LEA. And so the county doesn't have a policy-making function. The county is simply executing on the formula that's set in statute. And
well,
I think that
our decision in Weaver versus Ayers said that specifically in the context of school funding, the county's obligation is not ministerial, which I assume is what you're getting at. Obviously, that operates differently for counties who are not subject to the ESA. The county is not obliged to simply take the LEA's recommended budget, is it?
So I think the question is really...
That's a yes or no answer, and then you can explain.
The county obviously has some flexibility here, but fundamentally the BEP reflects the fact that it is the state that sets education policy in Tennessee. And the state, through the General Assembly, is responsible for making these decisions. It has made these decisions in the BEP, and it's made this decision to enact an ESA program.
And that decision is different for these two counties than it is for all the other counties in the state? Is that correct?
It is different for the school districts located within these counties.
And their counties in the funding obligation that they have, correct?
The counties still have the same obligation in terms of responding to the count given.
My question is it different than elsewhere in the state?
I would say it's not different in that they are obligated, like every county, to follow the statutes that the legislature has enacted.
But they're different statutes.
They are different statutes for the LEA. We should not lose focus on the fact that this is located in the education title and that the language of the statute sets responsibilities on the LEA as to how they count. They then turn those counts over to the counties. But it's not that the county is doing any different counting. It's the LEA is doing a different count and then turning those numbers over to the county, which then responds according to the formula.
Thank you.
I see my time has expired.
Thank you.
Your Honor.
Bonjour.
Good morning, Your Honors. May it please the Court. I'd like to reserve a minute for rebuttal, as the Chief said. The parent interveners submit that the Court's decision in Parrott controls and that the Tennessee Constitution requires enforcing the limits on a county's home rule authority. I'll address Parrott first briefly before turning to Power. Parrott v. Carter concerns education and the home rule authority that the county may have, and we agree with the greater praise interveners. It requires a structural argument.
The section in Parrott that the court was concerned with dealt with election laws.
Parrott v. Carter...
It did involve a special school district, but didn't the specific section they were worried about deal with election laws? Or am I wrong about that?
I think, if you look at Parrott, the reason it's on all fours with this case is simply that Parrott involved a law, and we have to look at the law being challenged, and it's a law that provided for children in a particular county to be educated outside of the county school district. And as in this case, the county had to continue funding for the education of those children, despite them not attending schools operated by the county school district. And as in this case, the law was challenged as a violation of the county's home rule authority, just like in this case. This court rejected that challenge, and it should do so here as well, because there was no home rule violation,
Was there
just
any
like this
finding
case.
that the county was substantially affected by this law?
There wasn't, Your Honor. That holding in Parrott turned on the structure, the entity, and held that, look, special school districts can't raise taxes, but neither can LEAs. I think if you take a step back and look at Parrott, it's a short opinion, and the result in Parrott is not surprising. And that's because historically counties have never had the home rule authority to have a say over what education benefits funding can be spent on. And that's what's happening in this case, the ESA. Or have a
Counsel,
say.
I'd like you to address the Hamilton County case that
Yeah.
Justice Lee mentioned.
So the Hamilton County case involves proprietary capacity. Chattanooga and Hamilton County owned hospitals. A law required the transfer of those hospitals to a district. And there, the dispute arose that the county was able to have a home rule referendum, but not the city. The city of Chattanooga disputed this. They also wanted a home rule referendum. And the court logically concluded that it didn't affect the county the same way, the city the same way as the county, because the law provided that the hospital district was able to exercise power and, quote, act on behalf of the county. It actually exercises the county's actual power. And, if we look at this case and look at it through the lens of power, the same thing applies. I mean, the reason Parrott is not a surprising holding is because under the Tennessee Constitution, the Education Clause grants the power to support education to the state, not just the mandate to operate a system of free public schools, which is in the second sentence of the Education Clause, but also to support the education of Tennessee children, which is the opening line of the Education Clause. That constitutional reality is reflected in Shelby County and Metro's own charters. Shelby County's charter, for example, says that, quote, the provisions of this charter shall not extend to county school funds, to the County Board of Education, or to the County Superintendent of Education for any purpose, end quote. So not only does it reflect the constitutional reality that education is generally vested with the state because the Constitution says so, the voters in Shelby County voted for a charter that has no power over education funds and expressly disclaims power, just to make it crystal clear. Metro's charter fares no different. They can't tell the school district how to count students at the school district depending on what education benefit they choose. And they can't tell the school district what education benefits can or cannot be available. So that's why to resolve this claim, since it's a home rule amendment claim, not an education clause claim, so private versus public doesn't matter, that claim is sitting in the Chancery Court still. For home rule amendment purposes, we asked this court to begin the analysis by defining the scope of the home rule authority. And that's in paragraph 5 of the home rule amendment, because paragraph 5 makes clear that a home rule authority is defined by a charter. It says, quote, the governmental and proprietary powers, duties, and functions, end quote. Now, it's important to note that that same term of art is in paragraph 2, the home rule referendum provision. A law, in part, to have a local referendum requirement has to be applicable, quote, in the county's governmental or proprietary capacity.
And do you agree that it does affect the county's governmental, if it does affect it all, it would affect them in a governmental capacity?
I think if it acts upon those powers. So for example, I guess the question to ask here is, if you have to look at the theory of causation that they've advanced, their theory of causation for a home rule violation is if a child enrolled in the school district walks into the school operated by the school district, no home rule amendment violation, they're fine with that. If a child enrolled at the school district does not walk into that school but opts to ask the school district to facilitate its ESA so it can go to get educational services where the school is not failing, like my clients want to do, then there's a home rule violation. The crux of their theory is on how the money is spent. And so the only question to ask here for home rule purposes is, do you have the home rule power, duty, or function to dictate to the school district how the money is spent? The answer is no, Your Honor. And so that's the only question that matters. Their theory of causation for a home rule violation is squarely at odds with their home rule charters. And the residents of that county insisted that the charter is what it is when they voted for it. And here, the home rule amendment is being weaponized to extinguish the children in that county's education benefits, something that there is no home rule authority over. And that's why the structural argument for a home rule amendment is important. The Court of Appeals departs from this way of looking at the home rule amendment, despite this court having, for the past 70 years, decided home rule amendment cases by, in the narrowest of senses, construing the applicability requirement by looking at whether a law is applicable in a governmental or proprietary capacity. All the cases in the case law involve quintessential home rule issues, selecting commissioners, runoff elections, the list goes on. None of them try to do this. What the court below did is say, the charters are irrelevant. We've already found that there's fiscal effects. And the fiscal effects here are the counties disagreeing with how the education funding is spent on Tennessee children. In another case, it'll be disagreements over where highway funding is directed to connect some counties but not others.
Isn't that, counsel, the whole purpose of the local referendum? That's the whole purpose of the home rule amendment. When it's directed at a particular county, then that county gets a say. It's not controlling the state. It's simply controlling the legislature's ability to do private acts.
Yeah, I think you have to look at if I may finish, Mr. Chief
You may,
Justice.
go ahead.
I think you have to look at the home rule amendment in the context of what the Constitution demands. And there it does grant some powers, home rule power, and in paragraph 5 it says how you enshrine those powers. But what it doesn't say is, if you don't have any power under your home rule charter, you can come to court and ask the court to exercise its judicial power to make up the difference here. And here that's what the counties are doing. They can't do what they're trying to undo, which is why they're here in court. Now maybe they have another claim. They just don't have a home rule amendment claim. And that's why we asked this court to decide the case under Parrott and to enforce the limits on power that exist under the Constitution and the grants of power. The Education Clause grants education powers to the state. The Home Rule Amendment says quite clearly that you have home rule, your residents have to approve it, and you have to propose the charter before you can exercise those powers. Those two things have to be enforced. Thank you, Your Honor.
Good morning, Your Honors. Bob Cooper of the Nashville Bar. May it please the court, here on behalf of the Metropolitan Government of Nashville and Davidson County and Shelby County Government. This court should affirm the ruling below. The Home Rule Amendment to the Tennessee Constitution protects counties and cities from local legislation that they have not approved. The ESA Act is just such a bill. It applies only to Davidson and Shelby counties. We've heard no dispute about that. It requires them to count private school students as enrolled in their public schools, and by doing so, it directly affects their sovereignty, how they are required to budget, tax, and spend for public schools. The Act does not provide for local approval as required by the amendment, so the Court of Appeals was correct in holding it void and of no effect. Very briefly, the Act works as follows. The state will pay into each education savings account an amount equal to the statewide average per pupil funding under the BEP. That money will be used by students only in Davidson and Shelby counties to attend private school. The Act then directs the state to withhold that same amount of money from this county school district, and then requires the counties to fill that hole. It does this by changing the general law for school funding through a provision called the counting requirement. The counting
Mr.
requirement
Cooper,
says
Mr.
that
Cooper.
ESA students, even though they have left the public schools, will still be counted as enrolled in their county school district, quote, for the purpose of funding calculations.
Mr. Cooper, is that in the record? Because the state has said that there is nothing in the record to support financial harm. And that was on their standing issue, but I think it would relate to the other as well. Does the record support what you're saying?
Your Honor, everything I have just described is all from the express terms of the ESA. And I would point out, Your Honor, that this is a claim under the Home Rule Amendment. The constitutional injury is that the counties were deprived of their local sovereignty because they were given no say over a local bill that applies to them in their governmental capacity. And based on the ESA Act's plain language, that is the case.
But Justice Lee's question was,
Yes.
is there financial information in the record that directly showing the financial impact on Metro and the financial impact on Shelby County?
Your Honor, there is information, but I would say that that financial harm is not an essential element of this claim. The harm is the injury to the sovereignty of the local government by not giving them the right of approval over an act that affects them in their governmental capacity. But, Your Honor, yes, there is proof of that.
Where do we find that in the record?
All of those numbers
What do you mean all those numbers?
that we can provide to you with regard to how much it will cost Davidson County and Shelby County
But is
per
that
student.
currently in the, was that in the record before the chancellor, when the chancellor made her decision
Your
on
Honor,
the motion for summary judgment?
It is the appellants who put this information into the record when they submitted, and this is in the trial court record, the comptroller's report on the ESA Act. The comptroller's report on the ESA Act goes through and shows what the average payment would be by the state into an ESA account, what the average per pupil funding would be. It also shows what Davidson and Shelby County are currently paying on their local BEP share, as well as the additional funding that they charge. And all of those numbers are part of that report, which the defendants put into the record in an attempt to support their claim that there is no standing here. So they certainly cannot argue now that we are not able to rely on the same document to rebut that claim.
Mr. Cooper, is that your answer to the question I asked General Blumstein about why the ESA and Home Rule Amendment are applicable to the counties versus LEAs? Can you go into that for me?
Yes. Your Honor, it's applicable to the counties because it is the counties, not the school districts, that have the sole responsibility for budgeting, taxing, and spending for their local schools. That's a matter of state law. As you know, school districts can propose a budget, but the county is not required to adopt that budget. The county has discretion because the county has to weigh what it pays for schools against its available funds, as well as other priorities of the county, such as protection, or health, or tax relief. And in fact, this court has recognized in Weaver versus Ayers that that is an obligation of the county. Now, the budget, that school budget that the county has to pass every year, has two mandatory components: the BEP match, local match, and maintenance of effort. And both of those components are based on the number of students enrolled in the public schools. Local BEP funding in every county is, quote, student-based, such that each student entering or exiting an LEA shall impact generated funding. Well, ESA students are exiting the school districts. That's, of course, the point of the program. But Davidson and Shelby will still have to count them toward their BEP match. And maintenance of effort in every county requires the county to keep its school budget at the previous year's level, except when student enrollment declines. Davidson and Shelby alone will not be allowed to reduce their maintenance of effort when their ESA students leave for private school. And there was some reference that these students are enrolled in the public schools, just going off to private school. Your Honor, the counting requirement applies not just to students leaving the county schools. The Act requires Davidson and Shelby to count and pay for students who will never set foot in their public schools, ESA students entering kindergarten, or who have just moved into the county. So the bottom line is that under general state law, every other county in the state can reduce spending when enrollment drops. But the ESA Act changes the rules for just 2 counties. They will be legally obligated to keep paying for students who don't attend their schools, and every student that leaves adds to that harm. And this interference in local sovereignty is exactly what the Home Rule Amendment was intended to stop. Now, let's go to this question. The state has said that there's no injury here because the Act will not require the counties to spend any more than they're spending now. Your Honor, that is not a solution to their case. That is exactly the problem. Under the ESA formula, the Act requires Davidson and Shelby to pay for the same number of public school students as before, even though thousands of them will have left for private school. And based on the comptroller's report, Davidson County will have to raise and spend about $9,300 for each one of those missing students, and Shelby County about $6,400. No other county is required to do this. That is real money being paid for ghost students who will never darken the doors of the county's public schools.
Well, does that mean that the public school students then will have less because money is going to these private schools? Is that a harm?
No, Your Honor, what has happened is the state takes money away from the school district, but the counting requirement requires the county to pay for the student as if the student is still in public school. So, we can see that the school district is not going to suffer. We'll have about the same amount of money. There are some variations
while the
in
grant
calculation
program
there.
is in effect, or
I'm sorry?
while the grant program is in effect, or after?
Your Honor, the grant program, we would say, is irrelevant to this because the grant program, if it's funded, and it has to be appropriated every year, so that is certainly hypothetical. But the grant program, while it provides funds to the school districts, does not provide any relief to the counties from their heightened obligation under the ESA. And let me explain that. Grants have no fiscal effect on the counties for at least 2 reasons. First, grant money does not change enrollment, and the county school funding obligation is based on enrollment. So regardless of how much grant money the school district might get, that doesn't change what the county will now have to pay, the enhanced amount under the county requirement. Second, the counties cannot use grant money to supplant or reduce their school funding obligations. In fact, it is illegal for the counties to use state money that way. That is the heart of the maintenance of effort requirement. It is even illegal for the school board to propose such a swap under state law. So, the grant funds may help the school districts, but that is irrelevant to this legal claim.
But Mr. Cooper,
Yes.
The way the process works, the board, Metro simply gives the LEA a set budget number.
Yes.
Correct. Which includes BEP funds, includes the maintenance funds, and includes also the additional local funds that are contributed, right?
Correct.
That's a total amount. You cannot dictate to the school board how that total amount's done. It's up to them to do that.
Absolutely.
So as a matter of fact, there is a pot of money there that the school board will have access to that includes that grant money. And you're saying that there's not going to be any consideration taken as to what resources there are for the LEA there when the county makes a decision as to what the total budget is?
Your Honor, what I'm saying is that certainly the county has discretion in spending. However, it has to start at a particular base of mandatory funding. And that base of mandatory funding is the local share of the BEP and the obligations of maintenance of effort.
But it still has control over what the final number is by its control of the discretionary spending.
Certainly it has its own discretion. However, that discretion has been reduced and limited by the counting requirement because Davidson County and Shelby County will have to start at a higher base because they're working at under a different formula than any other county. When students leave any other county's school system, the county has the option of reducing funding. Davidson and Shelby have been deprived of that discretion. This is now mandatory on them. And in fact, Your Honor, if you look at the case of Civil Service Board of Knoxville versus Burson, there you had an act that changed the rules with regard to Civil Service Board qualification and appointment. It applied to only 3 counties. In 2 of the counties, the municipalities already conformed, were already performing what the act required them to do. But the court still said, this court still said that those boards, those cities, were affected by the act because it removed from them the discretion to stop doing it in the future. So here, Davidson County and Shelby County, their discretion is being removed to reduce funding should they decide to do that. That is a harm. That is an effect. And this court has recognized it as such.
Counsel, go ahead, Justice Lee.
Oh, really quickly. So are you saying that there is no financial harm, or your argument does not depend on financial harm, but rather harm in that the county is being deprived of discretion of how to spend their education dollars?
Your Honor, we are first and foremost saying that this is an infringement on the county's sovereignty. However, we also argue that that has a financial impact on the counties because it increases what they are required to pay in their budget, and it deprives from them the ability to reduce their budget.
Because they're paying for students who have left the system.
They are paying for students who do not attend their schools. Exactly, Your Honor. And so while the total amount that they might be paying pre-ESA and immediately after the ESA, they'll argue that that number doesn't change and therefore there's no injury. That's not correct, Your Honor, because Davidson and Shelby have been deprived of the ability to adjust their budget, to shift money from schools to other things by this act, which requires them to budget in a way that is different than any other county. And that's really the core of this, Your Honor.
Well,
There's a different set of rules.
I want to go back to your comment there about
Yes.
that. Didn't Metro and Shelby County agree somewhere in the record, I don't have it right here in front of me, that in essence they would not be changing the amount of money that they were sending to the LEAs pre-ESA and post-ESA?
Your Honor, what the counties have said is that this act artificially elevates their funding obligation, so that if students leave under the ESA...
My question is a yes or no question initially.
Well, if students leave, they will still have to pay for them, and in that sense, they will be paying the same amount of money, yes, Your Honor. But no other county would be obligated to pay that amount of money because Under the BEP formula, when a student leaves, then the county is no longer obligated to pay for that student under the BEP formula and can reduce maintenance of effort under BEP statute.
Counsel, let me ask you to address an argument that is made by the BA interveners, that you are basically mixing up language that's in the Home Rule Amendment. It says it's local in form or effect, and the language saying that it has to be applicable to a county by saying applicable means the same as having an effect on. I'd like you to address that argument.
Well, certainly, Your Honor. We don't see a definitional difference between the two, and this court has not either. This court has often said that acts that affect a city or county, AFFECT, fall within the Home Rule Amendment standard of applicable to a particular county or city. So that seems to us to be a definitional difference that doesn't exist.
Mr. Cooper, don't we construe words in the Constitution very similar to our statutory construction? Every word is presumed to have meaning.
It is, Your Honor.
No words are put there to be superfluous, right?
That's correct, Your
So
Honor.
you're basically conflating Part 2 and Part 3 of the test, aren't you?
Let's see.
It says it must be applicable to a particular county or municipality. And number 1 says the statute in question must be local in form or effect. 2 says it must be applicable to a particular county or municipality, right?
Yes. Yes, Your Honor. Local in form or effect, the purpose of that language is to say that a bill should be considered local even if perhaps it does not have the trappings of a local bill. Let's say that it is in a part of a public act as opposed to a private act. Or in this case, their argument that this statute is about LEAs and not counties. Well, just the mere fact that counties are not mentioned in the ESA Act doesn't change the fact that the ESA Act does affect them, does have an effect on them.
But in order to get to the applicable language, basically we have to look at the county requirements and all the financial ramifications of this and agree with your position on that to rule in your favor, correct?
Your Honor, the applicable part, we would say that phrase, and this is clear from Delegate Pope's comments on the floor of the convention, the purpose of that phrase is to make it clear that, one, the Home Rule Amendment applies to cities and counties as opposed to other forms of local governmental entities such as special school districts or other special utility districts. And then the language governmental or proprietary capacity. So it's really applicable in the governmental or proprietary capacity. That is intended basically to show that it would apply to pretty much any sort of activity that the county would be engaged in, since governmental capacity deals with where a county acts basically as an agent of the state, or a proprietary capacity where it is dealing with purely local functions such as fire or police or something of that sort. So no, we don't see a conflict between the two of those. And I think the court historically has not either, since it has used those two words interchangeably, effect and applicable.
But the Home Rule Amendment doesn't use them interchangeably, does it? They're two separate.
No, but it uses. We would argue, Your Honor, that those are two different parts of the amendment with different purposes. One dealing with what is local, and the other dealing with what is the scope of the act as it applies to local government.
That's painting with a very broad brush, isn't it?
Well, and it was intended to be broad, Your Honor. The delegates to the convention made it clear at the convention that they wanted this Home Rule Amendment to have the broadest possible scope to apply to all local bills
Dealing with
legislation.
counties or municipalities, right?
Dealing with
Didn't
counties
mention
and
school boards
municipalities,
or
but not, no.
local education associations.
Exactly, Your Honor. But we're not making a claim here. And in fact, the school, the Davidson County School Board was dismissed by the trial court below as a party to this lawsuit. That has not been appealed. We are here strictly on the basis that this act does affect the Davidson and Shelby counties in the manner in which they fund their public schools by applying different rules to them than any other county in the state. Your Honor, I'd like to touch on a few
Counsel,
other
would
Yes.
you characterize the that as an incidental effect or a direct effect on the counties?
Your Honor, it is clearly a direct effect on the counties because public school funding is, again, the sole responsibility of the counties. So anything that deals with school funding is going to directly affect the counties. And Your Honor,
Mr. Cooper, would it be a substantial effect as discussed in the Chattanooga Hospital Authority case?
yes, Your Honor, it would be a substantial effect. We're talking about 5,000 students in the first year of the program, going up to 15,000 students by year 3 of the program. And when you look at how much Davidson and Shelby counties spend per pupil, then that number is quite a substantial number for each county. Now, all of the appellants, in talking about direct or indirect, have raised the question of the Parrott decision. And, Your Honor, we would suggest that the Parrott case provides them no help whatsoever here. Parrott involved the expansion of a special school district in Carroll County. And Carroll County, like every other county, has to fund all public school districts within its border based on pro rata public school enrollment. So when a student moves from a county school to a city school or into a special school district, as was the case in Parrott, the county's total funding obligation does not change. The ESA Act, however, creates an exception to this rule. School funding in Davidson and Shelby will no longer be based on public school enrollment throughout the county. It will be based on private school enrollment per the counting requirement, and that effect on the counties is direct, and it is substantial according to the Comptroller's report and the Act's fiscal memo.
I struggle to find much analysis in the Parrott case.
I'm sorry, Your Honor?
I struggle to find very much analysis in the Parrott case. Was I missing it, or is it there and I overlooked it?
Frankly, we are puzzled at the reliance by the appellants on the Parrott case. There is not much to it other than a holding that special school districts themselves do not fall within the Home Rule Amendment. And, Your Honor, that's exactly right. That was the intent of the convention when they adopted the Home Rule Amendment. That is why the phrase applicable to a county or municipality in its governmental or proprietary capacities was added to the amendment at the end of the process to make clear that the amendment applied just to counties and cities and not to other forms of local government, such as special school districts or utility districts or the like. So no, we don't see how Parrott provides any help to them, and in fact is consistent with the argument that we're making today. Your Honor, just would make a couple of other points before sitting down. The state has claimed that it has plenary authority over public education, and therefore its education bills are exempt from Home Rule Amendment scrutiny. This court rejected essentially the same argument in the small schools case in 1993 and should reject it again now. In small schools, this court said it had a duty to determine whether the legislature's school funding statute violated the Tennessee Constitution. And it held that funding statute unconstitutional, notwithstanding the state's claim of plenary authority. Well, this court has the same duty here to apply the state constitution where education funding rules have been changed for only 2 counties in violation of the Home Rule Amendment. Your Honors, if there are no other questions, to sum up, the ESA Act changes the education funding rules for only 2 counties, and it does this without those counties' approval. That is a violation of the Home Rule Amendment. As I noted at the previous argument, Convention Delegate William Miller said that the Home Rule Amendment is an essential restraint on the General Assembly's historic misuse of private acts because, quote, experience teaches us that the legislature cannot be depended on to pass a law taking away from itself the power to enact local legislation. Well, unfortunately, the ESA Act shows that old legislative habits die hard. We urge this court to enforce the Home Rule Amendment and affirm the Court of Appeals' decision that the ESA Act is void and of no effect. Thank you, Your Honors.
Thank you.
Just a few quick things in rebuttal. Justice Bivens, I believe that the statement that Metro and Shelby County made that their appropriations will not change is on page 31 of their brief, and it's also something that they said in the earlier oral argument in this case. Also want to point out that to the best of my knowledge, the comptroller report that the plaintiffs referred to as providing something in the record is not in the trial court record. I think that was something that came at the appellate stage. And just two other things to illustrate that the chancellor's point that none of these harms and how the math will work cannot be determined until the program has been implemented. A lot has been made about the number of students who will be enrolled in that or who will participate in the ESA program. The Act actually provides that if there are not enough applicants, if there are not enough applicants for the first year number of students or the second or third year number of students, then the number of students does not go up. So it may or may not come to pass that there will be X number of students in the ESA program.
General Plumsley, let me ask you this question with regard to the counting requirement. Isn't part of the purpose of the counting requirement also to allow for calculation of the grant money?
Yes, it is. And my very last point about this accounting thing is the plaintiffs have acknowledged that the maintenance of effort statute says that there's an exception if enrollment decreases for the maintenance of effort. And in the maintenance of effort statute, it says that that exception applies any other law to the contrary notwithstanding. So I think there is
So does the ESA.
Good argument to be made.
But so the ESA has similar language.
Not with that part of the.
So you're saying that the counties can
I'm saying that there's
disregard?
an argument that can be made for as applies to the maintenance of effort portion.
Well, I'm trying to understand what you are saying. Are you saying that the counting requirement does not require the counties to conform to it? Because the maintenance of effort statute
No, not
overrides
because
it?
of the maintenance of effort statute. I'm saying as pertains to what they have to count with respect to their maintenance of effort contribution, that there's an argument to be made that
What
does
does that
not
mean, there's an
apply.
argument to be made?
Well, that was not, it's a legal argument.
Okay.
That,
All right, thank you.
okay.
Thank you. I know it's hard to say your name in 1 minute, but do your best.
3 points, 3 sentences, Your Honor, and it's answering, I think, Justice Lee, your question about Parrott. You read Parrott, it cites Fountain City. Fountain City's talking about utility districts, but it compares it to other types of districts, and it says soil erosion districts, irrigation districts, and school districts. It doesn't say special school districts, it just says school districts. That language in Fountain City is then what the court picks up in Parrott. Parrott also talks about Key, where it again discusses all public school corporations, not just special school corporations. And the reason it talks about Key is that it says public schools lack the power to tax and special schools lack the power to tax. Therefore, they are not municipalities. Obviously, still today, LEAs lack the power to tax. And so in Parrott, the key distinction is the fact that schools aren't municipalities. And I think Mr. Cooper's conceded, as the framers wrote this provision, they were interested in cities and counties. They were responding to a problem for cities and counties. And I would just ask the court, ask yourself, are LEAs more like a special school district, or are they more like a county? Obviously, they're more like a special school district, and the reason in Parrott is they don't have the power to tax. Thank you, Your Honor.
Your Honor, just 3 brief points in rebuttal. The Home Rule Amendment concerns power. It grants power. Metro likes that, and so does Shelby, but they don't like the constraints on power, which the Home Rule Amendment also insists on, which is why you did not hear them defend one time that their charters expressly do not allow them to have a say over what educational options a school district can offer their students. Second, applicability is narrower than effect. Effect, local informer effect, applicability means something more. They conceded just now that the delegates came back at the end of the convention to add it, to narrow it, to add a requirement that insists on looking at the governmental and proprietary capacity. That points directly to charters, because paragraph 5 of the Home Rule Amendment points to charters. Finally, Your Honor, fiscal effects is not a substitute for these constraints on their power. Fiscal effects is a door that swallows the rule and lets anything be satisfactory of the constitutional requirements for a Home Rule referendum. Anything can have a fiscal effect if you disagree with the policy. We ask the court to reverse and send us back to the Chancery Court. Thank you.
Thank you all for those excellent arguments. We're going to take probably about a 15-minute break, and we'll be back in for the second case. Thank you.
All rise. This honorable court's now in recess.